Something big just dropped out of the Fifth Circuit Court of Appeals, and it could have major implications for gun owners across the country. A previous decision that claims suppressors don't qualify as arms under the Second Amendment has officially been tossed out. That earlier opinion has now been vacated, largely because the Department of Justice, back when it was under the Trump administration, flipped its position and admitted that suppressors do fall within the category of constitutionally protected arms. The court has since labeled the case as moot, so let's unpack what that actually means and what direction this case might take next. But before we dive into the legal details, I want to say this. If you're watching this, chances are you take your Second Amendment rights seriously. But here's a hard truth. Even the most law-abiding gun owners are getting caught up in legal trouble for things they never even realized were violations. Simple missteps can lead to serious consequences, including jail time. That's exactly why I put together a free resource called the Legal Survival Guide. It's a short, no-fluff PDF that'll take maybe 2 minutes to read through, but it could save you years of legal headaches. It won't cost you a dime, and you can either save it to your phone or toss a printed copy in your range bag. I even added a wallet-sized reference card with must-know legal pointers and emergency contact info, just in case you find yourself in a tough spot. Now, just to be clear, I'm not an attorney, and this isn't legal advice, but the guide is built to help you steer clear of some common traps that responsible gun owners fall into way too often. If that sounds like something you want to have handy, hit the link down below. Like I said, completely free. Just drop your email, and it'll be sent right over. Now, let's get back to the suppressor case. This one centers around a federal case titled United States v. Peterson. You might have heard of it. It's the same case that went before a 3-judge panel in the Fifth Circuit, where they initially ruled that suppressors don't meet the legal definition of arms, and therefore aren't protected by the Second Amendment. That decision hit hard, especially for those of us who care about firearm rights. The defendant, Mr. Peterson, challenged his conviction under the National Firearms Act, arguing that the restrictions placed on suppressors were unconstitutional. At first, the court dismissed that argument, saying that suppressors weren't considered arms in the legal sense. But then everything shifted. Pam Bondi, representing the Trump-era Department of Justice, filed a new brief reversing course. She argued that suppressors are protected under the Second Amendment, and that neither federal nor state governments can implement a blanket ban on them. The DOJ emphasized that while the National Firearms Act does regulate suppressors, it doesn't outright ban them, so, in their view, the law still fits within constitutional limits. That same brief also directly asked the court to reverse its earlier stance that suppressors don't count as protected arms. That was a significant pivot from the government's previous arguments, and the judges took notice. As a result, the same panel that had issued the original decision has now formally withdrawn their opinion. What does that mean in plain terms? Most likely, the panel is preparing to revisit the case and take a fresh look at whether suppressors are, in fact, constitutionally protected arms, and whether the National Firearms Act's regulations hold up under that scrutiny. That theory gained traction with a new update from the Fifth Circuit's en banc panel, which has declared the request for rehearing moot simply because the original ruling has already been withdrawn. To put it simply, since the first decision is off the table, there's no need for a full court review. For now, the case remains in the hands of those same 3 judges. So here's where we stand. The original ruling that weakened suppressor protections has been erased, and a new judgment could be just around the corner. Whether or not suppressors will finally be recognized as arms under the Second Amendment is still undecided, but one thing's for sure. This battle is far from finished. If you're not completely caught up on this case, let me walk you through the key details. This all kicked off back in the year 2022, when both state and federal law enforcement officers carried out a raid at Mr. Peterson's home down in Louisiana. The operation was pretty sizable. Roughly 50 officers made up a joint task force, which included personnel from the Bureau of Alcohol, Tobacco, Firearms, and Explosives. The search was tied to suspicions that Peterson was operating a small firearms business out of his residence. According to the ATF, there were several red flags. These included suspected straw purchases, inconsistent or sloppy record-keeping, and issues involving Form 4473 paperwork. One of the more serious claims was that a few of the guns sold through Peterson's business later showed up at crime scenes. But here's the kicker. The legal case didn't stem from any of those bigger concerns. Everything boiled down to one single object found during the search: a solvent trap. That single item was what triggered a federal charge under the National Firearms Act. And it's what led to this entire constitutional fight over Second Amendment rights. In response, Mr. Peterson's legal team filed a motion to dismiss the charge. Their argument was that owning the solvent trap fell under the protections of the Second Amendment. The trial judge didn't buy it and denied the request, which sent the case up to the Fifth Circuit Court of Appeals. Once the case landed in front of the Fifth Circuit, a panel of 3 judges sided with the ATF, and, at that time, the Biden administration. The court rejected Peterson's constitutional challenge and ruled that suppressors, at least in their view, were not considered arms under the Second Amendment. What made the ruling even more significant was the fact that this was the first time the Fifth Circuit had directly tackled this exact question, and they leaned heavily on precedent from other courts, which had also ruled against recognizing suppressors as constitutionally protected. The judges based their reasoning on both historical use and practical function. They asked whether a suppressor could reasonably be classified as a tool of offense or defense, whether it had the ability to strike or project force. Their answer was no. They pointed out that Peterson may view a suppressor as an essential part of a complete firearm setup, but the court did not agree. According to the panel, a suppressor on its own doesn't fire a round, can't operate independently, and has no viable use in self-defense unless, as they sarcastically noted, you throw it at someone. Because of this lack of standalone function, the court concluded that suppressors do not meet the definition of arms under the Second Amendment. That conclusion led the panel to affirm the lower court's ruling. In short, they decided that because a suppressor isn't necessary for a firearm to function, it doesn't deserve constitutional protection. But Peterson's legal team didn't stop there. They petitioned the full Fifth Circuit, what's known as the en banc panel, to revisit the case. At first, the Department of Justice, still operating under Biden-era leadership, held firm in its stance that suppressors were not covered by the Second Amendment. That position changed when the Trump administration's Second Amendment Task Force, under the leadership of Pam Bondi, got involved. In a new legal filing, the Trump DOJ took a completely different approach. They argued that accessories and firearm components like suppressors are indeed protected under the Second Amendment. The brief made it clear: banning items like suppressors puts an unfair burden on the fundamental right to keep and bear arms. In fact, the DOJ went so far as to say the government's earlier argument had been incorrect. That pivot marked a dramatic shift in the legal landscape, and it played a major role in what came next in the case. That said, the Department of Justice didn't completely flip its position. While they acknowledged that banning suppressors outright would violate the Second Amendment, they still backed the National Firearms Act's current structure, specifically the registration process and the tax requirement. Their argument was that these rules impose only a minor burden and are consistent with long-standing American legal traditions, particularly when you consider that suppressors can be misused in criminal activity. So while they agreed with Mr. Peterson's conviction, they urged the original 3-judge panel, not the full court, to take another look at the reasoning behind their decision. Essentially, they believed the panel landed on the right outcome, but used shaky constitutional logic to get there. Rather than pushing for a full en banc review, the DOJ suggested a simpler route: just have the same 3 judges revisit their earlier opinion and release an updated ruling that reflects this refined legal stance. And now it looks like that's exactly what's happening. The Fifth Circuit has officially issued an order confirming that the previous opinion in this case has been scrapped. In legal terms, they vacated the earlier ruling. So what does that actually mean for gun owners? It most likely means that the panel is preparing to issue a brand new opinion that better lines up with the updated interpretation of the Second Amendment, especially in light of the arguments submitted by the Trump-era DOJ. Now, here's where things get even more interesting. There's been movement on the legislative front as well. The Hearing Protection Act, often referred to by supporters as the Big Beautiful Bill, has just been folded into a larger legislative package. It made it through the Senate, cleared the parliamentarian, and passed a full floor vote. But before we celebrate, there's a catch. This version of the bill doesn't actually remove suppressors from the National Firearms Act. All it does is eliminate the $200 transfer tax, bringing the cost of acquiring a suppressor down to $0. Symbolically, it's a win. It sends the right message. But in reality, the paperwork, the registry, and the background checks are all still very much in place. So we haven't gotten full deregulation yet. That goal remains just out of reach, for now. What's important is how this new legal and legislative momentum might shape future court decisions. Not just in the Peterson case, but also in a separate suppressor-related lawsuit that's currently sitting on the docket of the United States Supreme Court. There's a lot happening all at once, with federal policy shifting, lawsuits evolving, and Congress actually showing some movement. This is a critical moment for gun owners, especially those of us who support the use of suppressors as part of responsible firearms ownership. As more news breaks, I'll be here to keep you in the loop. If you want to support the work one do, head over to my site armscholar.com. You'll find a ton of great resources, including the free legal survival guide I built to help responsible folks stay out of legal trouble. There's also gear, merch, and hand-picked deals that can help you save some money while staying prepared. Again, that's armscholar.com. I appreciate you being here. Make sure to hit that like button, leave a comment, and subscribe so you don't miss what's coming next. And always remember, this country was founded by thinkers, and it'll be protected by armed scholars.